Today, we are starting coverage of the state of Florida versus Sara Boone. Why? Because they are in jury selection. But seeing that her ninth attorney just came into the case like a month ago, there's been a lot of moments of them needing to handle pretrial motions. They are trying to get through pretrial motions and trying to finish up the voir dire of jurors and trying to seat an entire jury and get to opening statements and opening instructions today. I think it is exceedingly optimistic, that time schedule. So I'm going to be covering the pretrial motions from yesterday a bit, from today, and then we're going to go through, whatever happens in court today. For those of you new to this case, just in sum, it is going to be a difficult case at parts. A lot of this is on video. Sara Boone is accused of killing her boyfriend, Jorge Torres. He was playing a game of hide and seek with her, according to her statements to police, and she zipped him into a suitcase and then left him there, even as he was begging for his life. A lot of that is on video as she is mocking him. This happened in February 2020. She has been in custody since then. Last week, she denied a plea deal to the effect of 15 years for a lesser included crime. And now she is facing, if she is convicted of the second-degree murder, a minimum of 22 and a half years, a maximum of life. And as I talk about this case, you might hear me say the thing that she did, the crime that she committed. Yes, she is innocent till proven guilty. However, her defense in this case is either it was an accident or it was in self-defense. Her defense in this case is not, I didn't zip him in a suitcase. It's not, he didn't die because I zipped him in a suitcase. It is more of that realm of justifiable homicide is what she's trying to go for, that self-defense. Like, yes, he died. Yes, I did the thing that made him die. However, there's a reason I did the thing. And that's why you will hear me say back and forth the thing that she did, as opposed to that she is accused. Yes, she is the accused. No, she has not been convicted, but she is going to be arguing either this was an accident or that it was in self-defense. We will just have to see.
Judge, could I respond?
Why?
Briefly.
We've gotten far afield from the point. The point is, can you bring in evidence of self-defense or a self-defense argument before the defendant testifies? And once the defendant testifies, then the prosecution is going to argue, Your Honor, they have not met the burden.
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection.
Your Honor, I am going to like you so very, very much. What he said to the defense is the case law you cited is not germane. Sir, you brought receipts. They're just not for this. Wrong receipts, my guy.
And the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. In the state's argument,
the fact that the judge has had to reframe what the problem is like 4 times reminds me of arguing with, either defense attorneys who aren't listening to me, or sometimes my child who's like, but blah, 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 blah. I'm like, that is not the question we are trying to answer. It's like, but this is this. It's like, this is not what we're trying to answer.
As you know, we got on this case about 45 days ago, and I can't tell you how many pages.
Oh, no. Is it, Your Honor, we got on this case 45 days ago. You inserted yourself into all of this. She was representing herself, and you bounced your happy ass into court and said, I volunteer as tribute. You knew that this case wasn't getting continued. This case has been continued 16 times. The court said nothing is getting continued. And the court looked at this man and was like, this is not getting continued. You chose to be here. You volunteered as tribute. You didn't get volunteered. You chose. Okay? So don't even tell me he's going to get up in here and be like, Your Honor, we haven't had time to read all the medical records. Sir, what? That's what's happening, isn't it? That's what's going to happen.
Discovery there is that we've had to go through. And 2 or 3 weeks ago, the state
Cry me a
attorney provided
river.
us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications.
Tell your client she shouldn't have been talking so much from the jail.
Which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something.
If the state narrowed down the transcripts of her jail calls or the audio of her jail calls, then you would be saying that the prosecution was hiding things. So they can't narrow it down for you. They have to give you all of the evidence. But you knew this.
Something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe were incriminating to her.
Understood.
It depends what the fuck she says.
But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And
need
yes,
a
we
little
would have to
violin.
make some tie to Sara Boone's testimony to whether or not their medical records of the decedent, Jorge Torres, are admissible to corroborate her
They just
stories
said.
about the incidences of violence and whether they match up.
They just said they would allow his narrative when he goes to the hospital inn. So for our preamble day for the Sara Boone trial, I covered the motions from both Wednesday and Thursday for trial, where Sara Boone and her attorneys dealt with all of their motions in limine and objections to items of evidence and more. The defense renewed their motion for a bill of particulars, asking the state to lay out their case. Exactly why are you saying that this is a second-degree murder? And the state, towards the end of the hearing that occurred on Thursday, October 17th, stood up and really gave what I think will be part of their opening statement when we get there on Friday, October 18th, a recitation of the video Sara Boone took of her boyfriend, Jorge Torres, while he was in a suitcase, begging her to let him out, saying that he couldn't breathe, asking for help, and telling her that he was in distress. And the state also lined out that not only did she zip him into the suitcase and leave him there, but she flipped the suitcase over. She hit him with a bat while he was in the suitcase and more. So we are going to see these opening statements. I imagine some of what we saw on the record today will be in those opening statements. And there was lots of argument over Sara Boone's self-defense claim. So with the self-defense, the court has ruled that until Sara Boone takes the stand and establishes the legal grounds or foundations for a self-defense claim, that evidence of that can't come in. We're not going to see a expert or a witness testimony before Sara Boone gets on the stand to testify that are going to testify about any self-defense or battered spouse syndrome or any of that. It has to be established first, and the prosecution has repeatedly stated that they are skeptical that the defense can meet the legal threshold for that to be allowed in, including what was the victim doing that was the act that started this or prompted this? What was the overt act of the victim? And that is something that the prosecution is arguing the expert was silent on. The defense is arguing that the expert won't be silent on it when they testify in court. However, the prosecutor is saying that the differences in what was testified to in a deposition and what's testified to now is going to be difficult. And it's going to be difficult when you get to Sara Boone's earlier statements. She didn't state she was afraid of Jorge Torres. She didn't state that he had done something that caused her to be in fear in her earlier police interviews. So Sara's words are going to be what's used against her in this trial. And after all the motions in limine, what we saw is really the court narrowing down when evidence will come in and making sure that all the attorneys understand the foundation for that. The defense keeps iterating that they came onto this case 45 days ago, and it is a lot. And you can see that there is some disorganization in that due to the timing of when the defense came onto this case. It's quite a lot to deal with, but We will see Sara Boone testify in this case at some point, and we will see opening statements on Friday, October 18th, if all goes as planned. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.